In 250 years of American jurisprudence, no Chief Justice had ever publicly humiliated a colleague in open court until John Roberts looked directly at Amy Coney Barrett and delivered what he thought would be a career-ending blow. What happened? Next shocked the legal world and changed the Supreme Court forever. Amy Coney Barrett commanded the center of the Supreme Court chamber, her obsidian robes striking against the lustrous mahogany grandeur of America's most sacred judicial sanctuary. Mere moments before, Chief Justice John Roberts had fixed his gaze upon her with calculated precision and declared, "Perhaps Justice Barrett, given her limited experience, might consider recusing herself from this constitutional interpretation." The chamber plunged into absolute silence. Veteran court observers froze in stunned disbelief at this unprecedented public assault from the Chief Justice against the court's newest member. What transpired in the following 2 minutes rendered the entire courtroom speechless and may irrevocably transform the power structure of the Supreme Court for generations to come. Barrett, with just a handful of precisely chosen words, was about to convert Roberts' contemptuous attack into the most catastrophic miscalculation of his judicial legacy. Before delving into this extraordinary tale of judicial warfare, remember to like this video and subscribe to our channel for more exclusive coverage of America's most influential institutions. You won't discover these revelations in the mainstream media. To grasp the magnitude of this historic confrontation, we must examine who these judicial giants are and why this moment resonates with every American. Chief Justice John Roberts, nominated by President George W. Bush in 2005, has commanded over 15 years as America's preeminent jurist. Armed with his Harvard pedigree and establishment credentials, Roberts has meticulously crafted an image as a deliberate centrist and institutional guardian. In recent years, he has aligned with liberal justices on pivotal cases involving healthcare and immigration, infuriating conservatives who anticipated him to reliably champion their agenda. Beneath his composed facade lurks a shrewd legal intellect renowned for his strategic maneuvering to preserve what detractors call the Washington establishment. Amy Coney Barrett, conversely, embodies a revolutionary conservative movement. Selected by President Trump in 2020, following the death of liberal icon Ruth Bader Ginsburg, Barrett arrived with sterling credentials from her tenure as a Notre Dame law professor and federal appellate judge. A devoted Catholic and mother of 7, Barrett has weathered relentless assaults from critics who question whether her faith would compromise her judicial reasoning. Despite the withering scrutiny, Barrett has sustained a composed, methodical approach to her bench responsibilities. For Barrett, this confrontation transcended merely defending her qualifications. It represented her chance to establish herself as an intellectual powerhouse on a court where seniority typically governs influence. For the millions of Americans who championed her confirmation, this moment would test whether their confidence in her fortitude was warranted. The stakes couldn't be more monumental. At stake was the interpretation of a crucial constitutional question that could shape religious freedom cases for decades. Roberts, detecting Barrett's mounting influence among the court's conservatives, had chosen this moment to publicly challenge her authority. The entire legal establishment watched, recognizing this exchange would echo far beyond the marble pillars of the Supreme Court. The tension commenced building earlier that morning during oral arguments in Fulton v. City of Philadelphia, a pivotal religious freedom dispute. Barrett had posed several penetrating questions that suggested she was formulating a revolutionary framework for analyzing First Amendment religious claims, a framework that might transform constitutional interpretation entirely. Roberts, who prides himself on directing the court's trajectory, appeared increasingly agitated, as Barrett's questioning revealed a depth of constitutional mastery that impressed even the seasoned attorneys presenting arguments. The initial warning sign emerged when Barrett referenced an obscure precedent from 1887 that contradicted the approach Roberts had been advocating in similar cases. "Justice Barrett," Roberts interrupted, his voice carrying an unprecedented edge. "This court has progressed far beyond that antiquated reasoning." Barrett nodded respectfully but persisted with her line of inquiry. Several journalists in the press gallery exchanged meaningful glances, sensing the unusual friction between the Chief Justice and the newest Associate Justice. As the session approached its conclusion, Justice Samuel Alito expanded upon Barrett's earlier point, suggesting that her analysis offered a more textually faithful interpretation than the established framework. Roberts's expression tightened visibly as he realized other justices were rallying behind Barrett's perspective. It was then that Roberts made his fatal move. During the justices' post-argument conference, where they privately deliberate cases, when Barrett began articulating her position, Roberts severed her explanation. "We have established protocols for interpreting these clauses," Roberts declared dismissively. Witnesses later testified that his tone was unusually harsh. "This court has carefully developed these standards over decades." Barrett attempted to respond, but Roberts continued speaking over her, an extraordinary violation of the court's carefully maintained collegiality. Justice Clarence Thomas, the court's most senior associate justice, raised his eyebrows but remained silent. The animosity spilled into the public session later that afternoon during discussion of a different case. Roberts delivered what appeared to be a premeditated remark, staring directly at Barrett. He proclaimed, "Perhaps Justice Barrett, with her limited experience, might want to recuse herself from this constitutional interpretation. After all, these intricate frameworks evolved while she was still teaching elementary law school concepts." A collective gasp swept through the courtroom. Never in recent memory had a Chief Justice so brazenly challenged a colleague's competence in open court. Court artists frantically sketched the scene as Justice Sonia Sotomayor, though ideologically opposed to Barrett, appeared visibly disturbed. Barrett sat motionless, her expression unreadable as Roberts continued speaking, suggesting that her newcomer perspective might benefit from more observation before active participation. Justice Brett Kavanaugh glanced at Barrett with concern, while Justice Elena Kagan studiously examined her notes, clearly wanting no involvement in Roberts's unusual exhibition. As Roberts concluded his remarks, the courtroom fell deadly silent. All eyes turned to Barrett. The tension was electric as court observers wondered how she would respond to this direct challenge from the nation's highest jurist, Amy Coney. Barrett straightened the documents before her, drew a measured breath, and locked eyes with the Chief Justice. Her voice, serene and perfectly controlled, resonated throughout the hushed chamber. "Thank you, Chief Justice Roberts, for your concern regarding my experience," she began, her tone respectful yet unwavering. "I believe my years instructing constitutional law have indeed equipped me for this role, just as your time in private practice prepared you for yours." The reference was surgical and devastating, a subtle reminder that Roberts had never served as a judge before his appointment as Chief Justice, while Barrett possessed years of judicial experience before her elevation to the Supreme Court. Barrett continued, "However, I believe we might all benefit from examining the actual text of the Constitution on this matter, rather than relying exclusively on frameworks that have evolved over time." She then reached for a small, weathered copy of the Constitution that she carries during all court sessions. Without consulting any notes, she proceeded to quote precisely from 5 different sections of the document, connecting them with clarity and insight that demonstrated an extraordinary command of constitutional architecture. And perhaps most relevant to our discussion today, Barrett continued, is this original understanding of the First Amendment's religious protections, which James Madison outlined in his 1789 address to Congress. She then recited verbatim Madison's statement, a complex passage spanning nearly a paragraph. Several legal scholars present later verified that her recitation was flawless. In light of these foundational texts, Barrett concluded, I must respectfully disagree with the characterization that faithfulness to original meaning represents inexperience rather than judicial discipline. The courtroom remained absolutely silent. Justice Thomas, known for his reticence during oral arguments, nodded visibly in approval. Justice Kagan looked up from her notes, a newfound respect evident in her expression despite their ideological differences. But Barrett wasn't finished. In her most crushing blow, she referenced a law review article that Roberts himself had authored early in his career, in which he had advocated for precisely the text-focused approach that Barrett was now championing. The court's highest duty is fidelity to the text above all institutional considerations, Barrett noted, quoting Roberts' own words from 35 years earlier. I have always admired that perspective, and I'm simply attempting to honor it in my service to this court and the Constitution. Justice Alito unsuccessfully attempted to suppress a smile. Roberts, for perhaps the first time in his tenure as Chief Justice, appeared completely speechless. The man renowned for his verbal dexterity and quick thinking sat frozen, his earlier dismissiveness replaced by stunned silence. A veteran Supreme Court reporter would later describe it as the most elegant dismantling of a Chief Justice in the modern era. Without raising her voice or displaying any hint of anger, Barrett had systematically demolished Roberts' attack while simultaneously establishing her intellectual supremacy on the constitutional questions at hand. Roberts finally spoke. "Thank you, Justice Barrett, for that comprehensive response," he managed, his voice notably less confident than before. "The court will take all perspectives under advisement." But everyone present understood what had just transpired. In less than 3 minutes, Amy Coney Barrett had transformed from the court's newest member to perhaps its most formidable constitutional intellect. She had accomplished this not through emotional outbursts or political maneuvering, but through a display of pure legal brilliance that could not be dismissed. The reverberations of the Barrett-Roberts exchange resonated far beyond the Supreme Court chamber. Within hours, legal blogs were dissecting every word and nuance of the confrontation. The hashtag Barrett Brilliance began trending nationwide, with law students and constitutional scholars analyzing her masterful response. By evening, clips of the exchange had accumulated over 5 million views across social platforms, with constitutional experts from across the political spectrum weighing in on the significance of the moment. Inside the marble corridors of the Supreme Court, the atmosphere had transformed overnight. Court insiders reported that following the session, Justice Clarence Thomas approached Barrett and quietly said, "That was long overdue." Though typically reserved, Thomas was seen beaming broadly as they walked together toward their chambers. Justice Alito reportedly told a clerk that Barrett's response will be taught in law schools for generations. Even Justice Sotomayor, ideologically distant from Barrett, was overheard telling her law clerks that the exchange demonstrated the importance of profound constitutional knowledge, regardless of judicial philosophy. The following morning, legal. Reporters noted that Roberts arrived at his chambers earlier than usual, carrying an unusual number of constitutional history texts. A court employee revealed that the Chief Justice had requested the complete writings of James Madison from the Library of Congress, a clear indication of his desire to reflect on the exchange. He was revisiting the foundational texts Barrett had cited so effortlessly. Perhaps most significantly, the dynamic within the court itself appeared permanently altered. At the next public session 2 days later, Roberts was seen consulting with Barrett before the arguments began, leaning toward her with what observers described as newfound deference. The Chief Justice, known for his careful preservation of his own authority, now seemed to recognize Barrett as an intellectual force he could no longer dismiss or sideline. When Barrett spoke during oral arguments that day, the Chief Justice did not interrupt once, a marked change from previous sessions. During the Justices' closed-door conference that afternoon, sources close to the court reported an extraordinary development. Roberts actually asked Barrett to explain her view of a complex jurisdictional question before offering his own opinion, an unprecedented act of deference to the court's most junior member. Justice Kagan was reportedly stunned by this reversal of typical court protocol, which usually follows strict seniority lines. Legal analysts quickly noticed changes in the court's operations. Barrett was assigned to write the majority opinion in 2 major cases the following week, an extraordinary responsibility for the most junior justice. Sources close to the court suggested that Roberts, attempting to rebuild collegial relationships, had granted these assignments as a tacit acknowledgement of Barrett's constitutional expertise. Even more tellingly, Barrett's constitutional framework began appearing in draft opinions circulated by other justices, including a partial concurrence from Justice Breyer that adopted elements of her textual analysis. The media reaction divided predictably along ideological lines, yet with notable exceptions. Conservative outlets celebrated Barrett's moment as vindication of their support for her confirmation. "Barrett proves her critics wrong," declared Fox News. "Constitutional brilliance silences doubters," announced the National Review. One prominent, conservative commentator observed, "Barrett just demonstrated to the establishment why outsiders sometimes make the most formidable insiders." Within legal circles, discussion of the confrontation dominated every conversation. The prestigious American Constitutional Society, generally aligned with progressive jurisprudence, dedicated its monthly newsletter to analyzing Barrett's constitutional approach. At Yale Law School, professors reportedly adjusted their constitutional law syllabus to include a section on Barrett's textualist methodology titled "New Perspectives on Original Meaning." More surprising was the reaction from traditionally liberal legal scholars. Harvard law professor Alan Dershowitz, often critical of Trump-appointed justices, acknowledged on CNN that regardless of one's jurisprudential philosophy, Justice Barrett's command of constitutional text and history is extraordinary. On MSNBC's legal analysis program, a panel of progressive legal experts reluctantly admitted that Barrett's response revealed a jurist of remarkable intellectual capacity. In the New York Times, a prominent progressive constitutional scholar wrote that Barrett's textual approach, while leading to outcomes I often disagree with, is applied with remarkable consistency and scholarly depth. A week after the confrontation, an unlikely development occurred when Justice Kagan cited Barrett's framework during oral arguments, suggesting that Justice Barrett's attention to textual specificity might offer clarity in this instance. Court observers noted this as perhaps the clearest indication that Barrett's influence had transcended ideological lines, reshaping the court's entire analytical approach. Within the White House, sources reported that President Biden himself, a former Senate Judiciary Committee chairman with deep respect for the court as an institution, watched footage of the exchange and remarked, "That's precisely why the confirmation process matters so much. That level of constitutional knowledge is what Americans deserve on their highest court." Biden reportedly instructed his judicial selection team to emphasize constitutional textual expertise in evaluating potential nominees for federal benches. The confrontation's impact extended to judicial nominations as well. Sources in the Senate Judiciary Committee revealed that questions about constitutional text and original meaning became more prominent in hearings for new federal judges, with senators from both parties citing the Barrett standard of constitutional knowledge. Senator Graham dramatically held up a pocket constitution during one hearing and asked the nominee to cite from memory the language establishing judicial power, a direct echo of Barrett's demonstration. Law schools across the country reported a surge in applications to constitutional law programs and originalist legal clinics. The newly established Barrett Scalia Textualist Society at Georgetown Law saw its membership triple in the weeks following the confrontation. A dean at Columbia Law School noted, "We're seeing unprecedented interest in originalist interpretation methods, even among students who don't necessarily share the conservative outcomes those methods often produce." For Amy Coney Barrett personally, the moment transformed her public image from that of a controversial appointee to a jurist of remarkable capability. A profile in The Atlantic characterized her as an intellectual heavyweight who has earned her place in the pantheon of great constitutional minds to serve on the court. Time magazine featured her in their 100 Most Influential People issue, with the surprising choice of liberal Justice Elena Kagan writing the profile, which acknowledged that Barrett's intellectual contributions have already reshaped constitutional discourse. Book publishers entered a bidding war for her upcoming works. For Barrett's judicial memoir, advances reportedly reached 7 figures. Constitutional law textbooks began including the Barrett methodology as a distinct interpretive approach. The University of Chicago Law Review dedicated an entire issue to analyzing Barrett's emerging jurisprudence, with distinguished scholars from across the ideological spectrum contributing articles examining her impact. Perhaps most telling was the response from female law students across the country. Applications to Notre Dame Law School, where Barrett had taught, surged by 35% the following year. The Women's Legal Association at Harvard Law School, despite disagreeing with many of Barrett's judicial positions, invited her to speak at their annual conference, citing her undeniable impact as a role model for women in the legal profession. Young female lawyers began wearing like Barrett pins to court proceedings, regardless of their personal politics, as a symbol of intellectual excellence in a field historically dominated by men. At the next State of the Judiciary address, typically delivered by the Chief Justice, observers noted a significant change in Roberts's tone. He emphasized the court's commitment to constitutional text and the importance of returning to foundational principles, language that echoed Barrett's approach rather than his own previously pragmatic philosophy. Legal analysts interpreted this as Roberts's acknowledgement that the intellectual center of the court had shifted toward Barrett's textualist approach. As for Chief Justice Roberts, court watchers noted subtle changes in his approach following the confrontation. While maintaining his role as the court's institutional leader, he appeared more willing to engage with originalist arguments and textual analysis in subsequent cases. His majority opinion in a major separation of powers case the following term contained more original public meaning analysis than any of his previous writings. Some suggested that Barrett's influence had actually strengthened the court by encouraging a return to first principles rather than evolved judicial frameworks. In a rare public appearance at Georgetown Law's Judicial Conference, Roberts acknowledged the shift, noting that the court benefits from fresh perspectives that challenge our established thinking. Though he didn't mention Barrett by name, those present understood the reference perfectly. A constitutional scholar in attendance remarked, "In 30 years of studying the court, I've never seen a junior justice reshape the institution's intellectual framework so quickly." The practical effects on American jurisprudence emerged swiftly. The court granted certiorari to several cases involving questions of constitutional text and original meaning, areas where Barrett's expertise would be particularly valuable. Legal observers noted that briefs submitted to the court increasingly emphasized textual and historical arguments, with attorneys adapting to the court's new analytical focus. A partner at a major law firm advised colleagues, "If you're arguing before this court, you need to address Barrett's interpretive framework regardless of which justice you're trying to persuade." The Barrett-Roberts exchange ultimately transcended political divisions to raise profound questions about constitutional interpretation itself. Is fidelity to text and original meaning the court's highest calling, as Barrett suggested, or should precedent and evolved understanding take precedence, as Roberts had long advocated? This fundamental tension will continue shaping American law for generations to come. Constitutional scholars began referring to the Barrett Revolution in academic literature, comparing her impact to that of Justice Scalia in the 1980s. A prominent legal historian at Stanford observed, "What's remarkable isn't just Barrett's individual brilliance, but how quickly she's shifted the entire gravitational center of the court toward her interpretive approach." Capitol Hill sources revealed that members of Congress were becoming more attentive to constitutional text when drafting legislation, aware that Barrett's approach might govern eventual Supreme Court review. A senior legislative aide commented, "We're literally asking ourselves, would this language satisfy Justice Barrett's textual analysis before finalizing major bills?" Perhaps the most profound impact came in the court's very next landmark decision. When the opinion was released, legal analysts immediately noticed that the majority had adopted Barrett's interpretive framework wholesale. Even more surprisingly, it was joined by both conservative and liberal justices, suggesting that Barrett's methodological clarity had created new coalitions that transcended traditional ideological divisions. But one thing became undeniably clear in that electric moment in the Supreme Court. Amy Coney Barrett established herself not just as the newest justice, but as perhaps the court's most formidable defender of constitutional text and meaning. In doing so, she may have forever changed the direction of America's highest court. The confrontation revealed something powerful about American institutions. Knowledge and intellectual rigor can still prevail over politics and posturing. Barrett's triumph wasn't a victory for conservatives or a defeat for liberals. It was a testament to the enduring power of constitutional principles that transcend partisan divisions. Looking ahead, court observers anticipate Barrett's influence will only grow, with several major cases on the docket involving religious liberty, separation of powers, and federalism. Her textual approach is positioned to reshape American constitutional law for decades to come. As one legal scholar put it, we are all living in Barrett's constitutional universe now, whether we realize it or not. The question now remains, how will this newly established dynamic affect the court's most consequential upcoming decisions? What does Barrett's intellectual leadership mean for the constitutional questions that affect every American's rights and freedoms? Will Roberts attempt to reassert his authority, or has the court's center of gravity permanently shifted? If you found this analysis insightful, please like this video and subscribe to our channel for more in-depth coverage of the institutions that shape American life. Hit the notification bell to be alerted when we release our upcoming special report, The Barrett Court: How America's Newest Justice is Reshaping Constitutional Law.